very good evening to all of you friends. A very good evening to all of you. Welcome to this very important session on Maharashtra CET Law Entrance Examination. Now, in this particular session, friends, we shall be discussing some very important questions relating to Maharashtra CET Legal Reasoning section. Now, Maharashtra CET, the kind of questions that come in Maharashtra CET is similar to the CLAT old pattern question. So the questions that are asked in your Maharashtra CET exam, legal reasoning section, is absolutely similar to what used to be asked in CLAT. Now, right now in CLAT you get passage-based questions. But in Maharashtra CET, the kind of questions you get, they are all principle and fact-based question, meaning thereby you will be provided with a principle of law, a statement of law will be provided. After a statement of law is provided, okay, what will be provided thereafter? A set of facts. A small little story will be provided, and thereafter some options with a question. You have to mark or tick the right option and get the full marks. Okay, so are we all ready? Are we all ready for this particular session, guys? A very good evening to all of you. A very good evening to all of you. How many people are there now? Let's check out. Just tell me a hi. Just give me a hi on the chat box so that we can begin with this particular session itself. Okay, so a very good evening to all of you. A very good evening to all of you. Today we are talking about some expected legal aptitude or legal reasoning questions for Maharashtra CET. Okay, so let's get started, guys. Let's get started then. Let's get started. Okay, now let's see the first concept. We are going to understand certain concepts of law very briefly and proceed with answering certain questions. The first concept is trespass. Now, trespass is of two types: trespass to land and trespass to goods or trespass to body. Now, trespass to goods is direct or indirect damage to someone else's goods. Now, if you are not the right owner of a particular goods, and if you directly or indirectly cause any damage to such a good that does not belong to you, that is called trespass to goods. Trespass to land. Trespass to land means if you are barging, if you are entering into someone else's land without the owner's permission, that amounts to trespass to land. Okay, now, so these are the two important concepts. Let's start with the question itself. Let's see what the principle says. Let's read the facts and start solving. If you are entering into someone else's land without a lawful justification, it is trespass. Okay, let's see the correct answer. The correct answer is M has reasonable lawful justification to say that his eyesight was weak and there being no boundary between the gardens, he entered into that person's land. Now, is it a case of trespass? Yes, it is a case of trespass, but there is a justification. He does not see well, and there is no proper boundary between the two gardens that were adjoining. Moving on to the next principle, or rather the next question. This also deals with trespass. Now, here is a principle which deals with trespass to goods. If you do not have a title over a particular good, can you take that good away? Okay. Now, the correct answer to this question is yes, Poisden can be held responsible for the trespass of goods. Okay. Trespass of goods, he can be held liable. He can be held responsible. Am I clear? Is that clear to all of you? Okay. He can be held liable. Okay. The correct answer is option B. The correct answer is option B. Okay. So he has removed a particular car away. That is not done. Okay. Moving on to the next important concept, vicarious liability. Now, vicarious liability is a concept whereby for the wrong committed by one party, that party is not held liable, someone else is held liable. For the wrong committed by the servant, the master will be held liable, provided he was doing an authorized act and the wrong was committed during the course of employment. So there are two important things that you must keep in your mind. Okay, there are two very, very important things that you must keep in your mind. Number one is course of employment. And the second one is an authorized act. So vicarious liability is a principle whereby for the wrong committed by the servant or by the agent, principal and agent, or partners in partnership. Did you all understand? These are the three relationships where the principle of vicarious liability work. Read the question very carefully. Okay. The principle of vicarious liability is given, as well as the principle of negligence is also provided. Now, there is a trust owing to which one neighbor has given some cash to the other neighbor. Over here, Tom Cruise has given some money, some cash to Kate Holmes to get that money deposited in Tom Cruise's account. The money was misplaced. The money was misplaced. Now, is the bank liable? Now, has the bank ever authorized Kate Holmes to collect cash from any customer of the bank? The answer is no. The answer is simple, no. So the bank cannot be held liable. The bank cannot be held liable. Is that clear? So the correct answer is option B, that although there exists a relationship that was there, but over here, owing to the fact that here is a situation wherein there was no explicit authority given by the bank to his employees to collect money or cash from other customer. So the bank will not be held liable. Is that clear? Am I clear? Okay. The next question is up there on your screen. Now, what is the role of a driver? What is the precise role of a driver? To drive a vehicle? To drive a vehicle. Now, if a wrong is committed while driving that vehicle, the master can be held liable. But over here, the servant, the driver, beats up his wife, his own wife. Will the master be liable? No, not at all. Not at all. The correct answer is option C. Master cannot be held liable. Over here, he is acting outside the course of employment. Over here, he is acting outside the course of employment. The next question. Now, there is a case of medical negligence in a hospital. There was some fault in the oxygen supply. So, a fault was there in some equipments which was in a hospital which was maintained by Glenn. That's the crux. And the patient, of course, suffers an injury that he dies during operation on the operation table. Now, what is important over here? What is the most important thing over here? Who is liable? Is the hospital authority liable? Of course. The correct answer is option B. The hospital authority is definitely liable. The hospital authority cannot say that there was some fault in the oxygen and I am not liable. There is some problem with the infrastructure of the hospital. Is that clear? Moving on to the next concept called negligence. So what exactly is negligence? Suppose I am a doctor. I have certain duties, certain responsibilities towards my patient. Am I clear? Suppose I am a doctor. I have certain duties, certain responsibilities toward my patient. Now, if I do not follow those duties, those responsibilities, and because of my fault of not following the duty properly, the patient suffers some injury, I am negligent, right? I am negligent. So the concept of negligence is that there is a duty of care. Okay, there is a duty of care. That duty of care is breached. And that gives rise to some injury. Only then it is called negligence. So negligence is that concept. Am I clear, everyone? Okay. Is that clear? All of you. So negligence is that particular concept where there is a duty. That duty is not followed. There is a breach for which there is an injury that is caused. Let's read the next question. Now you go and give your vehicle to a shop for repair. He takes the car out and hits a vegetable seller. Who will be held liable? Let's see the correct answer. Option D. Very, very important. Whoever drives a car illegally is bound to take reasonable care for it, failing which he or she is liable. I give my car to a repairing shop, and that man drives a vehicle, he meets with an accident, I will be held liable. Next question. So guys, if you are enjoying this particular session, do press the like button also and share this video with your friends. Share this session with your friends so that people get benefit out of these sessions that we are giving to you. Okay, please. Negligence. So, for a case of negligence, there has to be a duty of care, and there is also a breach of that duty of care, right? So here is a person who was driving his car on the road, and B was crossing it. B stopped to look at A and got hit by another car from a different direction. Let's see what is the correct answer. Let's see. Tell me fast. Is A liable? Did A had a duty of care? Did he breach it? Or whether A is not liable? And the correct answer is option C. Okay, the correct answer is A did not had a duty of care towards B in this particular case. Okay, sorry. I'm so sorry. The correct answer is over here. A has breached his duty of care. Sorry. See, when you are in the street, when you are in the road, you have to see who is passing in and around. You have a duty of care towards the pedestrians in the road. You cannot say he has a duty towards people who are crossing. Is that clear? Okay. Just a sec. I think A was driving his car on the road when B was crossing it. B stopped and looked at A. A got hit by another car. Okay. The correct answer is not B. The correct answer is D. The correct answer is D. Sorry. I think I got confused with A and B. Sorry. B is the right answer. D for donkey. Okay. Is that clear? He got hit by another direction car. Okay. I think this is wrong. Yeah. The next question. A was driving with high speed on a blocked road which was under maintenance of a work. A car overturned and one of the workers died. Now, it's a road which is under maintenance. Now, you are driving that vehicle at a very, very high speed. Will you be held liable? Yes or no? The correct answer is yes, he is to be held liable. There was construction work going on that road. You are coming at a very, very high speed. You are coming at a very, very high speed. Definitely, you owe a duty of care. You have breached that duty of care for which there is an injury. The next question. Now, two people are walking in a park or in a pavement, and because of certain construction problem, the wife falls down, suffers from some injury. Now, the husband wants to sue the corporation. Will he be successful? Will he not be successful? And the correct answer is yes. Most of you have given me the right answer. Now, the corporation who is duty bound under the law to take care about the roads, the drainage system, they are under a duty to take care about these things. Now, if they do, the fact that there was some problem in the arrangement of the bricks, what has happened is simply this, that somebody falls, somebody is injured. Who is then responsible? The corporation. Okay, moving on to the next important concept. The next important concept is the concept of volenti non-fit injuria. Now, what is volenti non-fit injuria? It's a defense under law of tort. Now, these are certain justifications which can be used by a person against whom there are allegations of having committed a civil wrong. So, in case there are any allegation against me that I have committed a civil wrong, what are those arguments that will be beneficial for me in a court of law? And one of that defenses is the concept of voluntary non-fit injuria. Now, if I know about a risk, I am aware about a risk, I know the pros and cons of that risk. Even after knowing the risk involved, I participate. I fully participate even after knowing the risk involved. And later, if I suffer some injury, can I claim compensation? The answer is no, I cannot claim compensation. For example, I go to play cricket, to play football with my friends, and you must be knowing that a game of football is a body-to-body contact game. Since it is a body-to-body contact game, if someone pushes me or dribbles me, what do? I fall down. I get injured. What do? Can I claim compensation? I was aware that in a game of football, somebody might push me or pull me. I was aware of that situation. So later, I cannot claim compensation. Okay. Please. Okay. So here was a snake charmer who was showing all these snake charming things. Somebody stops to join the gathering that was watching that snakes dancing. Now that man unfortunately was bitten by this snake. Okay, let's see the correct answer. Let's see the correct answer. The correct answer is absolutely. Now, the moment you stop your vehicle to see a snake charmer performing in the street, you know that this is poisonous snakes. These are snakes. They can bite you. It is absolutely possible for them to bite you. So, you have given your consent to be injured by the fact that you stopped and you joined the gathering to watch this snake charmer performing. Okay. The next concept is of damnum sine injuria. Damage without injury. Okay, so it is damage without injury. That means there might be a loss, but there is no violation of legal right. So there is no violation of your legal right, even if you suffer some losses or some damages. The biggest example, of course, is the Gloucester Grammar School example, where, somebody constructs a school next to another school, and as a result of the new school coming up, the old school suffers financial loss. No compensation was granted in that case also, right? We are just revising. Let's see. The same example, Gloucester Grammar School example. Will the new school have to pay compensation? Will the new school be liable to pay compensation? Very good, very good, very good. There is no violation of a legal right. Unless and until there is a violation of a legal right, how can you claim compensation? For you to be eligible to get compensation, there must be a violation of a right. Building a new school next to an old school is no violation of someone's legal right. Am I clear on this? Have I made myself clear? Okay, so guys, if you're liking this session, do press the like button. Okay, do not forget to press the like button. Okay, moving on. The next question is from presumption of death. Okay, let's see the correct answer. If a spouse is not heard of being alive for a period of 7 years, the individual, the other person can go to the court and ask for an order of a divorce. Okay. A was deputed to a foreign nation in lieu of work on 12/12/2012. A then, wife of B, married C on 10/10/2020 while A was serving on his deputation. Is the marriage valid? Void? The correct answer is it is necessary for presumption of death that the person is not heard of. Now, over here, he is on a deputation in a foreign nation. That means he is out for a work. Just because two people are not physically staying together, it is not. If you have not heard about that person for 7 long years, if you have not heard about the other person, that whether he is alive or dead, only then is that clear? Is that clear to all of you? Okay, so the correct answer is option C. Only if you have not heard about that individual. Just because the husband is staying somewhere for 10 years doesn't mean that he is not been heard of. The next concept is cheating. Now, what is this concept of cheating? Cheating is a concept which says that if you are dishonestly deceiving someone, whereby you are asking that man to deliver you certain property, you are asking that person to deliver you certain property which he would not have delivered if you had not dishonestly deceived him. The fact that you have dishonestly deceived a person, by deceiving him, by fraudulently deceiving him, he is giving you certain property which he would not have given if you had not deceived him. That is called cheating. So deception is an ingredient, part and parcel of cheating. Is that clear? Is that clear to all of you? Let's see the question. Let us see the question. Okay. Okay. Is that clear? So you understand the legal principles. What is the clear meaning of cheating? That has been explained over here. Okay, over here. Okay, let's move ahead. The question is up there on your screen. Which is the most appropriate answer? Now, you know that the diamonds that you are giving to someone is all false. They are not the original diamond. They are not diamonds at all. Please, they are not diamonds. You are intentionally deceiving someone so that he or she lends you some money. Lends you some money. Is he guilty? Look at this. Sorry, not B, C and A. Let's see the correct answer. C. Both A does not give the proper meaning over here. This is incorrect. Whereas option C, she falsely represented these articles to be the real ones, thereby asking some money. Right? So the correct answer is option C. Is that clear? So today we did vicarious liability, trespass. We also did certain other important concepts of cheating. Right? Now, voluntary non-fit injuria. So we are just in these sessions just aiming for better things to happen. Okay, so guys, with this we come to the end of this particular session. Thank you very much. God bless you. Stay home, stay safe. Tomorrow I will come again with another set for Maharashtra CET Law Exam 2022 preparation, most expected question part 2 tomorrow. Till then, bye bye, take care. Definitely a very good evening to all of you. Bye bye, see you tomorrow.